What's the difference between a village claim and an occupational disease workers' comp claim? Well, the village claim, or the village, that comes from the village case, and essentially, if you suffer an injury that is developed gradually over a period of time, that can be an allowed claim. It doesn't have to happen from a discrete, explicit, concrete event. It could just be doing something over a period of weeks. The courts have said, 3 to 4 months is okay. 10 years, maybe too much. A year, maybe too much. So that's a village claim. An occupational disease is essentially the injured worker has to show that their work history created a hazard distinguishable from employment generally, so meaning the general public, and created a risk of contracting whatever condition they're pursuing in a greater degree, in a different manner from the public in general. So this comes up with folks who develop bilateral, or well, not bilateral, but either bilateral or unilateral carpal tunnel syndrome from typing. And the Ohio courts and the Industrial Commission had basically said, hey, there's everybody types, and everybody types a lot. So claiming that you developed carpal tunnel from typing, they're generally going to deny those. And what we have here in this full commission order dated April 10th, 2025 was an individual who was a meat cutter, and he tried to pursue, he said, hey, I developed tendonitis from cutting meat, and I've been doing it for 10 years. And again, the full commission said, well, that can't be a village claim because it's a 10-year period and it's not an occupational disease. And the reason why they said it was not an occupational disease in this situation, because I think it perhaps could be, because who's cutting meat all the time? The only person who's cutting meat would be a butcher. But the problem in this case is the guy didn't give specific evidence of the motions and the actions that he was doing cutting meat, and so that's kind of why they denied it. There was insufficient evidence, so to speak. But I also think in this instance, in this particular full commission order, and again, this is April 10th, 2025 full commission order, as they disallowed this individual's claim, because I think the Ohio and the Industrial Commission is reluctant to make employers responsible for the general wear and tear that an employee suffers throughout working their entire life. So they don't want to make the last employer be responsible for all the work that person had made throughout their life. Is that fair? I don't know, but that's the law in Ohio. If you want to change, ask your representatives.